Well, we finally reached the point where we can talk specifically about how to complete the most frequent notary act, and that is the acknowledgment. First of all, we want to talk about what an acknowledgment really is, what it means, and why it's so important. Before we begin to talk specifically about completing acknowledgments, I want to remind you that you must first examine the document for completeness. As we've said before, a notary may not take an acknowledgment on a document that is blank or incomplete. However, the notary may ignore those areas that are to be completed a little later on, such as information that's going to be placed in the document by a county clerk or a recorder, or for additional signers whose signatures aren't being notarized by the notary public at the moment. Secondly, the identity of the signer must be confirmed by using the methods we covered in the previous sections under identification. Finally, be sure to enter all the information into the notary journal as we described in the previous section under journal entries. Now we're ready to complete the acknowledgment portion. An acknowledgment simply means that the document signer has acknowledged to the notary that he or she signed the document and that the notary properly identified that signer. We'll look at the specific wording of an acknowledgment for California, but I want to reiterate that the notary wording, regardless of the state, will include something about the document signer acknowledging that they signed the document, and it's through this wording that you'll know that it's the acknowledgment notary act which is to be completed. For example, the notary wording appears at the bottom of this grant deed. And within the notary wording, you can see that the document signer has acknowledged to the notary that he executed the document. Executing the document simply means that he signed the document. When the notary completes an acknowledgment, the notary is certifying, and under penalty of perjury, 3 important facts about that signing event. First, the signer personally appeared before the notary public on the date indicated and in the county indicated in the county section noted as the venue portion of the acknowledgment. That the identity of the signer was based on satisfactory evidence, and that the signer acknowledged signing the document and did so in his or her own authorized capacity. Now, the process for completing an acknowledgment is always the same. First, examine the document to be sure it's complete and it doesn't have any blank or incomplete spaces that needed to be completed first. Remember that you'll have to be presented with the entire document in order to ensure this examination. Second, confirm the identity of the signer based on satisfactory evidence. Use the identification procedures we've already discussed. When a signature requires an acknowledgment, the signer may have already signed that document before it's even brought to the notary for notarization. If the signer's already signed the document, you'll need to obtain an acknowledgment from that person that they've signed the document since you didn't physically see him or her sign. So how do you do this? Well, you just ask, is this your signature? Or did you sign this document? If the document is not yet signed, then of course just ask the signer to execute the document at that time. So there are 2 ways for a signer to acknowledge his or her signature to the notary. First, the notary receives an affirmative response from the signer when they're asked about the signature that's already there. Or secondly, the notary watches the signer sign the document. Now, the other part of this is that when the document signer acknowledges their signature, that acknowledgment simultaneously indicates to the notary that they have the authorized capacity, or that is, the right or the title that is required by the document to sign that document. So, for example, if the document's supposed to be signed by a CEO or by a trustee, the person who signed the document represents with their signature that they have the authorized capacity or that they hold that representative title. The notary in California is not permitted to verify that title. So while a notary in another state may be required to see, say, articles of incorporation or something like that to verify that the signer is indeed the CEO, for example, in California, that is not the case. And in fact, it's illegal for a notary to do so. It is the signer who acknowledges their signature and the authorized representative capacity to sign that document, and it is not the notary's responsibility or duty to verify that capacity. Following the signature acknowledgement, the notary should complete the notary journal and then complete the wording on the acknowledgement and use the notary seal to complete the notary process. This is the California Certificate of Acknowledgement, which is either pre-printed on the document or is added to the document using an acknowledgement stamp, for example, or a separate acknowledgement sheet. The document signer will need to sign the document, but the notary must ensure the completion of the acknowledgement portion. And of course, the notary must sign underneath the section that states, "I certify under penalty of perjury under the laws of the state of California that the foregoing paragraph is true and correct." The certificate of acknowledgement must be completely filled out and must include the notary's signature and the notary seal. It's always the notary's responsibility to ensure that the acknowledgement is the correct form and that it's filled out properly. The notary may never place a notary seal or signature on the acknowledgement before that wording is completed. I also want to remind you that the acknowledgement is signed under penalty of perjury, so never complete an acknowledgement for someone who is not physically present before you at the time of notarization or for someone who cannot present satisfactory identification. Of course, a notary may notarize the signature on any document, whether or not that document originates in California. But California notary law is very specific when it comes to notary wording. Remember that when someone brings a document to a notary, the document will already have notary wording either pre-printed or attached to the document. If the notary wording is not already pre-printed or attached, or otherwise suggested by the wording of the document, then the notary must ask the client what's required to be done. If the notary act to be performed is an acknowledgement, the notary will already know that by the wording. The notary won't have to guess what's going to be required, and the notary is not permitted to tell the client what is required. If the client doesn't know, then the client must find out from the entity that originated the document or who's going to be receiving the document. Okay, now other states will have their own notary wording for acknowledgments, and many documents that have been created in California will have wording that's different from the wording we just saw. That's because notary law changes over time, and many documents created in the past here in this state still retain old and outdated wording. So this is the important rule about using different wording for acknowledgments. If the document is going to be used in California, the acknowledgment wording must be exactly word for word without any differences the same wording as we just saw. We'll look at the wording again so you'll know what to look for. Now, if the document is going to be used or recorded outside of California, we may complete and seal that state's wording, which is often, by the way, very different, but we'll need to read through that wording to ensure that it's not requiring a notary to certify the authorized capacity of a document signer, for example, or to do anything else that's going to be illegal for a California notary to do. If it does, then you will not be able to complete that acknowledgement, and you'll need to attach a California acknowledgement certificate. That's called a loose certificate, or if there's room, you can put an acknowledgement stamp on the document, but you'll need to attach somehow a California acknowledgement to that document. By the way, don't use a paperclip for the attachment. You should always attach a loose acknowledgement certificate with a staple. Now, if a document is to be sent outside of the United States, then the acknowledgement wording must be California acknowledgement wording, and remember, it must be in English. The notary is not allowed to use an acknowledgement in another language, even if the translation is accurate California notary wording in that language. It must be in English. So you might be wondering what an acknowledgement from another state may look like, and how to determine if it contains wording that would be illegal for a notary in California to complete. Well, this is an example of a notary acknowledgement from another state, and this example requires a notary to verify or certify the authorized capacity of the document signer. Now, notice that this acknowledgement requires that the document signer has proved to the notary his or her authorized capacity. I've changed the text color of this section to red. This is an example of an acknowledgment that a notary in California may not complete, even if the document is going to be used out of state. Part of the notary's responsibility is to verify the identity of the document signer, not the title that the signer claims to hold. In this case, the notary would need to attach and complete a California acknowledgment, or if there's sufficient room, use an acknowledgment stamp. Be sure to use the notary seal only on the document with the correct acknowledgment wording in order to complete the notarization according to California notary laws. By the way, of course you can obtain an acknowledgment stamp from notaryclasses.com, as well as a CD with lots of notary forms, and that includes an unlimited supply of acknowledgement forms. Let me just restate that the notary seal may not be used on a document unless it contains proper notarial wording. This is the proper notarial wording for a California acknowledgement. Let me also restate that a California notary must use California acknowledgement wording for all documents that are going to be recorded in California or outside of the United States. If a document is going to be used out of state, a notary may use that state's acknowledgement wording as long as that state's wording doesn't require the notary to verify the authorized capacity of the signer or to do anything else that might be illegal for a notary in California to do, such as rely exclusively on personal knowledge for identification. So let's take a closer look at the California acknowledgement wording. The first part of the certificate of acknowledgement indicates what county the notary public and person making the acknowledgement are located. This section is known as the venue statement. The venue statement establishes where the notary public performed the acknowledgement and where the signer personally appeared before the notary. The state is always California, since the notary public has jurisdiction only within California. The county should be completed with the name of the county where the signer personally appeared before the notary public and acknowledged the signing of the document. Since a notary can provide services anywhere within California, the county in the venue statement may not necessarily be the county where the notary public has his or her principal place of business, which of course is the same as the county where his or her oath and bond are on file, but it must be completed with the name of the county where the notarial act took place. All right, we'll enter the day, month, and year, which must be completed with the date that the signer personally appeared before the notary public and acknowledged signing the document. The notary must insert his or her name and must include the title Notary Public after the name. In the next space, the notary enters the name of the person who's acknowledging their signature on that document, and that goes right here after the words personally appeared. Now the notary should go through here and correct the wording forms, and then the notary signs and stamps the certificate with the notary seal. Be sure to notice that the notary signs the acknowledgement under penalty of perjury, and the penalties are very severe for falsifying the acknowledgement. Because the notary is signing the acknowledgement under penalty of perjury, misrepresenting anything, including dates, names, identifications, or venue, is considered forgery. If the document pertains to a deed of trust, the penalty may be even escalated from a misdemeanor to a felony. Never backdate or predate an acknowledgement, and never enter the name of someone who did not personally appear before you at the time of notarization. So let's look at an example of a properly completed acknowledgement. I'm going to increase the size of this document to take a closer look, but for now, the first step is to examine the document, making sure that you have all the pages included and that the document does not include any blank spaces or incomplete places. Let's take a closer look at this document to see what I mean. This document's a grant deed. Now, you may be wondering, how in the world would you know whether a document is missing information, especially if you're not familiar with the document? The requirement is that you only inspect the entire document for areas that are obviously blank or incomplete. If you're familiar with a document because you happen to work in that field, then there'd be a greater expectation that you'd be able to notice greater details of any blank or incomplete spaces, but you're certainly not expected to know or even understand every document you see. It's enough to examine the document in its entirety for obviously blank or incomplete spaces. The top portion of this grant deed appears to be in good order, so let's move on to the rest of the document. A document requiring an acknowledgment may be signed before it's brought to the notary or in front of the notary. If the document's signed before, the notary simply asks the signer to acknowledge their signature or signatures by asking them something like, "Did you sign this document?" or "Is this your signature?" When the signer or signers respond, "Yes, it is," they have acknowledged their signatures. Otherwise, the document must be signed in front of the notary. Then the notary completes the acknowledgement process. The very last step is to put the notary seal on the document next to the notary signature. Let's take a look at this acknowledgement and how this has been done. We see the venue is the state of California. It's the county of San Bernardino. That's where the Notary Act occurred. And the Notary Act was completed on April the 11th, 2013. Before me, now this is the notary's name and followed by the title Notary Public. That's Daniel C. Jones, comma, Notary Public. If you don't put the Notary Public in there, the county recorder will probably reject the document. Personally appeared. Well, what goes in this section? It's the name or names of the parties who had their signatures notarized on April the 11th in 2013 and in the county of San Bernardino at that particular time. So you'll put their names. Notice at the end of the names I've put a line so nobody else can add somebody else's name to that acknowledgement section, and that's for my protection as well as William A. Jones and Mary B. Jones's protection. Now, who proved to me on the basis of satisfactory evidence to be the person? In this case, I've circled the S because you can notarize multiple signatures at one time. That's no problem. But they're still two different notary acts, and when you put them in the journal, you're going to record them as two separate notary acts. So we're circling the S for persons whose names, again, I'm circling those. R, I'm circling R. By the way, some people will also cross off the word is, and that's fine, and circle the R. That's not a problem. You can certainly feel free to do that, and maybe that's even a better way to do it. Subscribe to the within instrument and acknowledge to me that they executed the same in their authorized capacities, and that by their signatures on the instrument, the persons or the entity upon behalf of which the persons acted executed the instrument. Boy, that's a lot, isn't it? But really what that's saying is that they are acknowledging to you with their signature that they executed the document and that they have the authorized capacities to do that. Okay, in other words, they hold the proper titles and so forth. So it's not up to the notary to verify those titles. All right, this is the critical part of the acknowledgement. I certify under penalty of perjury, under the laws of the state of California, that the foregoing paragraph is true and correct. You cannot predate, postdate, put a date on an acknowledgement that is a date other than the date that the persons personally appeared. Also, never complete an acknowledgement for someone who does not personally appear. I want to give you a very quick example. Suppose you're an employee notary and your boss wants you to notarize a document for him or her. And so they bring you the document and say, "Here, I'm going to put it in your in basket. Go ahead and notarize it whenever you get around to it." Well, maybe they take off and they're gone on vacation, or they're on a business trip, or whatever it is. And when you finally get around to notarizing it, you start filling out the acknowledgement. But you are filling out an acknowledgement for a person who is not personally appearing in front of you, and that is illegal. You are signing this document under penalty of perjury. This is extremely important. All right, enough said about that. Witness my hand on official seal. You'll see that's you'll sign the acknowledgement here, and the notary seal is always placed as close to the signature without touching any of the wording, without touching signatures, without touching lines, without getting too close to the edge. Put the seal as close to the signature as possible. Now, if you don't have room for that notary seal, don't just flip the page around and put it on the back. You'll need to attach an all-purpose acknowledgement. Again, you can get those from the CD. We have lots of notary forms on our CDs, so just download them, download as many as you like, and be sure to take some with you, or you can use an acknowledgement stamp if there's enough room. All right, let's move on to discuss the second most completed notary act, and that is the jurat.